Welcome to HBTV. I'm Harry Binswanger, the HB in HBTV, and my special guest today to discuss property rights is Adam Mossoff, who is professor of law at George Mason University and a director and founder of the Forum for Intellectual Property at the Hudson Institute. Welcome, Adam.
Thank you, Harry. Pleasure to be here.
Last couple of times we've been talking about the origin of property rights in the sense of how unowned materials come to be property. And the principle that I called upon was you have a right to use things without interference by someone who comes later. And that then eventually this becomes objective as a permanent condition you want to have over a certain piece of property, and if you register it with the government and so forth, it becomes your full property, whereas use rights is for as long as you're using it. That raises a question of what happens if you stop using something, even if it was property. I know there's a doctrine called adverse possession. You want to talk about that?
Oh, sure. And thank you again for having me. It's really exciting. And yes, I actually really enjoy teaching adverse possession every year, my first year property class, because it's a really fantastic doctrine that gets at this exact notion that the core of property is about securing this exclusive use right. And that not only is it use that creates property, it's use that sustains one's actual moral claim and ultimately one's legal claim to owning something, even though we've moved into a much more complex civil society in which you can own something without actively using it at that moment. And so you have situations where people buy property, they own vast tracts of property, and they're not using that property or all aspects of that property at any particular moment. That doesn't mean they lose it. But if someone comes along and starts using that property, and establishes a valuable use of it for themselves. So the term of the law is improvement, but improvement doesn't mean like they create economic value. It just means they make changes to the land in some way, shape, or form. They build a house. It could be an ugly house that could have zero market value, but it doesn't matter. It's their house. They're living in it, or they till the soil, or they cut down trees for timber, or they're doing something with the land that is value oriented. And that they're therefore acting openly as an owner of the land in doing this. So they're not hiding their activities either. If they do this for a very long period of time, most statutes set about 20 years. And if the title owner hasn't come along at a certain point and said, you're trespassing, get off my land, then what was originally a trespasser and becomes a squatter, after the certain period of time is deemed to actually have a more valid claim morally to the land, and through an action, legal action, and through the doctrine of adverse possession, they can obtain actually transfer of title to them. It's a fantastic doctrine. It's often portrayed by leftists as this great kind of Marxist doctrine that, oh, this is how the oppressed working class can stick it to the capitalists who own all this property. But actually it arose in the 18th century under Lockean influences in common law that really emphasized strongly that property is not defined by a piece of paper from the government that says you own it. Property is defined by your use and creation of some valued asset in the world and your continued relationship with that asset through your ongoing use of it, even if it involves kind of periodically checking your land to see if someone's on it.
Well, that is very interesting because it does concretize, make dramatic the fact that use is the origin of property and make such a logical transition from unowned wilderness to the final stage of having a deed, to land. But there's more kinds of property than just land, right? Contrary to what you hear sometimes.
Yeah. Yes. One often hears of, well, when we talk about property, we mean land, right? and I hear this all the time also from my first year property students. And it's something you spend a lot of time in your first year course kind of disabusing of them of this error. Property as a concept refers to the values, the material values that one has created, and it's acting to sustain in one's life, either through active use or disposing of them, trading with other people. And a property right is what secures this kind of domain of exclusive use for you to do this in your life. And so it refers to any material values that one has created or anything that one can convert into a material value out of either nothing through a pure invention or an artistic creation, or through kind of natural resources that have no value that you then turn into a value, like the oil that was literally seeping out of the ground in Pennsylvania for centuries, and the American Indians used sometimes to coat their canoes with, but it had no real significant value until, of course, combustion engines were starting to be invented in the 19th century. And so, property exists, and property rights therefore exist in all values that humans create, which means you have property rights in land, of course, the classic examples of farming, that John Locke used and talked about, but you have property rights in what we call chattels, personal property, your computers, your coffee mugs, but you also have property rights, therefore, in any other thing that is turned into a value. So you have property rights in spectrum, in radio spectrum, as we've developed the technologies for radio and digital transmission signals and things of this sort. You have property rights in corporations. You have property rights in credit, and then, of course, in cash in your wallet. You have property rights in in legal judgments. Legal judgments have value. They can be traded.
You mean a decision by the court that this guy has to pay you? That's what you mean by judgment?
Yes. So what happens is that those of us who are old enough to remember watching television very late at night, sometimes you would see commercials by lawyers say, "Have you won a massive tort award?" And there'd be dollar bills floating down behind them on the TV screen, and they would say, "You could sell them your award for a certain price, because sometimes you would get a structured settlement where they would pay out the award at a slower rate." And but also, and of course, this is why inventions through patents and artistic works like books and movies through copyrights and even trade secrets, so formulas, commercial customer lists and other things, can also be defined properly as property and secured as property rights to their creators and owners.
You are famous or notorious, depending upon how you view it, and I view it as famous for emphasizing that intellectual property is not an offshoot, but is the paradigm case of property that, in a sense, underlies all the other forms. Could you explain that?
Sure, delighted to. And this is another example of how it creates a lot of unnecessary confusion by starting from land as kind of your baseline and thinking land is what we mean by property and everything else has to be understood by reference to land. If you start from that perspective, you'll be completely confused by intellectual property.
Yeah.
And so the point being that, but land is not property. So soil is not a value. In fact, we often say, "Oh, but the farm." But the farm is only property to a farmer who has tilled the soil and used his mind to think about, how do I grow crops? I need to grow crops to live. How do I grow them? What crops should I grow? I shouldn't grow arsenic. I should grow corn, and then proceeds to engage in those value creating activities in the real world. And so ultimately, at root, what makes the farm a value is not the soil. It's the value oriented actions that the farmer is undertaking to convert that soil into a farm.
So, if I can jump in, it's rejecting the mind-body dichotomy. You're saying all human value creation involves the use of the mind and the rearrangement of matter. It's both, and it's not just the rearrangement of matter, it's the purposeful under the control of a mind for some intention. It's use. Not just change. Yeah, well, that fits right in with objectivism, and I know that Ayn Rand said that intellectual property protects the principle behind all property, and I guess that's what you're saying.
Yes, that man's mind is the root of all property.
Yeah.
And this is why she recognized in patents in particular as kind of the heart and soul of what we mean when we talk about property,
Yeah.
because patents do literally protect the direct inventive byproducts of the human mind. Because one doesn't go into the forest and find cars, air conditioners, computers, homes, automobiles. I mean, everything that has to be invented. Because one can argue, well, but trees, that's wood. You cut down the tree, make a chair, and things of this sort. But you don't look at trees and from that see a computer. And the patents that secured in innovations that went into creating the patents are properly the protection of these values that have been created by the person who conceived of something and then took the actions, the productive actions, to create that conception in the real world as a real world technological invention. I know there's some confusions because we often speak of patents as securing ideas, but that's literally not true, because that would mean thinking about an invention would be patent infringement, and that's not the case. It's protecting the actual invention in the real world.
And the market value of it really, isn't it? I mean, that if you invent something and don't care whether anybody else follows your lead and does the same thing, you wouldn't seek a patent.
Well, not necessarily. You might. In fact, a lot of people do seek patents without the intent to actually actively deploy them in the marketplace, because they use them for purposes other than licensing or commercial sale, which makes sense if you think of these as property rights. Property rights is about securing an exclusive domain of use where you get to control how something is used and disposed of. So an example is that the discoverers of the AIDS virus received a patent on it. And the reason why they obtained a patent on it was not because they wanted to license it, was because they wanted to ensure that researchers had access to it. And so that was the way that they could do that. They could say, we have got a patent on it, and as the owners, we're saying anyone can access this for research purposes.
Yeah, I guess that's right, because I'm on the board of the Ayn Rand Institute, and we have trademarked the name Ayn Rand, and we want to do that to protect the integrity and purity of what is presented as Ayn Rand, not to make money off of it. We're a charitable, tax-exempt organization. So, yeah, I guess that's a true wider principle. Thank you.
And that's a type of valued use of a product, just as much as, for instance, someone who obtains, for instance, title to land through adverse possession, for instance, but has no interest in selling. They just want to have that for their home and do nothing else with it, and maybe keep other people off, but they put up a bunch of no trespassing signs. We would still say they have a valid property right because they're using it in their life for the goals and values that they're pursuing.
Mm-hmm. There's an entirely separate issue that both of us want to get into, which is how far does property rights, going back to land, how far did they extend? I mean, physically, like obviously your fenced-in land ends at your fence, but what about air rights above and mineral rights below?
Yeah, that's a great question. There's a lot of really confusions about this, not just among regular people, but among lawyers and judges, in part prompted by this beautiful maxim from the common law in England. It's very long Latin, but it goes by the shortened phrase ad colum rule, which
Colon.
Ad colum rule. And it roughly translates, the longer Latin phrase roughly translates as, to him who owns the soil also belongs the heavens and the depths of the earth. And this was actually first popularized in the common law in the 16th century by Sir Edward Coke. But it existed before that as just a general saying, but he popularized it as a maxim in the law at that time. Now, of course, in the 16th century, there weren't airplanes, there weren't even hot air balloons, there weren't telephone wires. And of course, there in the 16th century too, people weren't drilling for oil and gas, and people were starting to dig into the ground to get coal and things of that sort, but not very deeply. And so it wasn't an active legal rule. It never was intended to be one. because it couldn't have been, because there weren't questions about the use of the air or what you could do half a mile under the ground. People owned land, the topsoil, for purposes of building homes and often 1 or 2 stories at most, or farming. And so, but this maxim, though, was articulated by Sir Cook and repeated by judges, because it captured this notion that if you own property, particularly land, you have complete and total exclusive control over that, as long as you are not interfering with the rights of other people. A more popular phrase also that was articulated by Sir William Blackstone in the 18th century is that property is that sole and despotic dominion that one man claims and exercises over external things in the world, to the total exclusion of every other individual in the universe.
Well, that's true.
Yes,
that part is true.
Well, yes and no, right? Because if you took that literally, right, that means you could do anything, including, well, I own property in my gun, so I'm just choosing to dispose of my property in your body. Oh. which you think that's a crazy argument. People have made it in court.
Think of that.
And so it's like, no. He was, again, he was just giving kind of a very beautiful, eloquent statement, in the same way the ad coelum rule captured that what property means is this domain of control over exclusive use of whatever is yours. But unfortunately, as technology developed, I shouldn't say unfortunately, fortunately, as technology developed, and as people began to be able to use the air, especially in the 20th century with airplanes, courts by the 20th century forgot that this was just a generalized maxim, and they came to think of it as an actual rule. And they said, oh, well, okay, well then airplanes flying over property are violating their property rights, they're trespassing. And there were actual lawsuits on this. A very famous one in 1946 called United States versus Cosby, where a farmer sued actually the government, saying, you owe me compensation for authorizing airplanes to fly over my property at 10, 20,000 feet, because I own that, because of the ad coelum rule. And that was rejected by the court, and rightly so, because the farmer wasn't using the air 20,000 feet over his property. In fact, the airplanes weren't interfering with his property at all in any way, shape, or form in his use of the farmland. So, so they rightly dismissed his argument. Unfortunately, this rule has led to two kind of concerns. One is it confuses people about what is the actual scope of property rights, because it divorces the property from the idea of use and of exclusive use, in which the property right is securing. But then secondly, by grappling onto this rule as a rule, not as a general expression of what it means to own property, then when the rule is rejected, people say, see, we have to modify property rights when other social circumstances require. And this is actually what these cases have come to represent in the law today, is that, well, we have to roll back property rights and modify them as technology evolves, as society evolves. And so leftists have used this as a basis by which to argue that, well, property at the end of the day is just a social construct that we redefine and reshape as social conditions require.
According to utilitarianism, the greatest good for the greatest number, right?
Yeah.
So it would hold up progress or something if the planes weren't allowed to fly over at 20,000 feet. So we make whereas the right approach we're saying is you weren't using that, and the plane going over doesn't interfere with any use. Now, if the plane went over at 200 feet, that would be removing your right to quiet enjoyment of your property, right?
Yes. And in fact, and there are cases like that actually in the early years of airplanes as well. And there's a fantastic doctrine in property law called Nuisance Doctrine. So nuisance is distinguished from trespass. So trespass is when someone actually physically comes onto your land. Nuisance is when someone is using their property and they don't actually physically come onto your land, but their use of their property results in an interference in the use of your property. So it raises directly this fundamental concern about property securing exclusive use. And there are concurrent cases, along with cases like Cosby that I just discussed, where low-flying airplanes over farmers who had cattle and chickens, and those chickens became terrorized by the low-flying airplanes and stopped laying eggs and were starting to attack each other. So there was harm to the farmer's crop and his ability to farm and continue farming from the airplanes. And in those cases, the airplanes were held to be committing a nuisance over the farmer's existing use of his or her property, and the airplane company had to pay.
What about, I was going to go first of all to beneath the surface, to mineral rights, because
Yes.
I claim, and I think you agree, that you don't own stuff 200 feet or more below your land. If taking it out doesn't affect you, you don't know it's happening.
Mm-hmm.
It's silent. That your neighbor drills horizontally, diagonally. That's perfectly correct. That he should do that. He should be protected in his right to do that.
Yeah,
I assume you agree with that.
and yes, in principle, and again, the law has kind of, because the law evolves historically, um, with the right principles, but because the law evolves historically, you get a lot of kind of confusions and understandable confusions about why these things should or should not be should or should not happen. So you've always had, as part of your property right, what in property law we call a right of lateral support and a right against subsidence. So your neighbor
Mm-hmm.
can't dig a massive ditch that causes your entire front yard or backyard to collapse into his yard. That interferes with your current
Yeah.
existing use of the soil. And of course, the same principle, your neighbor can't dig below your property in a way that causes your property to collapse into a gigantic
Right.
hole in the ground as well.
Right.
Both of those would interfere with
But
your existing value.
you don't own the minerals that are so deep that extracting them under your house, that extracting them would be something you wouldn't even know is happening.
Right. Well, and historically that couldn't have happened, right? So historically, given the nature of mining technology in the
Yeah.
18th, 19th centuries, subsidence and collapses from lack of lateral support happened all the time, which is where these rules developed and
Mm-hmm.
evolved. And so now, of course, today, right, with advanced drilling technologies, where they're drilling a mile below the surface, right, that has zero impact on your property. Now, if that causes oil to seep up into the soil, into your land, then
Yeah,
you can
yeah,
sue for
obviously.
trespass and nuisance and all the ways in which they've
Yeah,
interfered with your property rights.
yeah,
But that you, because you own the soil and have built a house and are farming or have a herd or something else on top
yeah.
of the land, doesn't give you rights. You're not actively using, you do not have a value in anything, as you said, 200 feet, or I even say 100 feet today, but it's certainly not miles below the surface, which is the level at which oil and gas is being drilled.
Right. And that covers a lot of attacks on capitalism, but a non-polemical thing that I don't know exactly the answer to is, what about two companies drilling from different land into the
Yeah.
same oil pool? They don't even know the size of the pool. They don't know if they're affecting each other. How
Mm-hmm.
does that get adjudicated by the principle of use?
Yeah, that's a fantastic question.
And that
And
gets into riparian rights.
yes, well, riparian rights, which are water rights, not for oil and
Yeah, I
gas.
know, but it
Yeah.
raises the
Mhm.
same
Yeah.
question.
So and I'm going to answer it by not answering directly your question, but another I'm going to give another example, which has nothing to do with oil and gas, but because it relates to it, and that is, this is not a new issue. So there were property disputes all the time where, for instance, two people were chasing a fox at the same time,
Oh.
and one person got it before the other, and the other person said, well, I've been chasing him for 6 hours, you just came in at the last minute and grabbed him, so I get him. There's actually a very famous case about this that we all teach in your first year property law, and
Hmm.
it involves the exact same question that you just raised about the oil drilling, because both of the people could claim, I was productively laboring, I was trying to engage in the use and acquisition of the fox, the other guy just got it first. And
Can I guess?
Mhm.
Let me guess.
Okay. Yes. Yeah. All right. Go ahead.
Yeah, it's in an unknown forest, although it's the forest
Hmm.
of the
Hmm.
Lord or something, but
Hmm.
it's unknown. The
They quit on
guy
the
who
beach. Yes.
gets it, unless the other guy is within line of sight, I would think the guy who gets it gets it.
The guy who gets it gets it. So the court announced what becomes known as the rule of capture for wild unowned animals. The person who gets their hands on the fox gets it. And the reason why is because this principle of productive labor, which is how they called it, which is what they identified it as in the common law, and we would refer to as actual exclusive use, more to be more objective. It doesn't differentiate between the two different claimants in this instance. They both can argue I was engaging in some type of use, and so the court has to shift to another principle in the law to help adjudicate this dispute. And in this instance, the resolution is there's greater certainty and objectivity with a person having their hands on the fox, as opposed to saying, well, pursuit establishes some initial claim, because then it gets to raise, well, how long do you have to pursue and how close do you have to be? Line of sight, 6 hours, 4 hours, 2 hours. And then you no longer have notice about who has rights and who has liabilities under the law, and every case becomes kind of a crapshoot as to whether one person will win over the other. And so concerns about certainty, which ties into concerns about rule of law, the ability to kind of settle on a fixed rule. For instance, we voted 18. Well, why not 17? Some people are smart enough and competent enough to be able to vote at 15, or some people shouldn't vote at all until they're 60 or never at all. So why 18? Well, because we have to identify a rule for rule of law purposes and stick with it. And so in instances where where use and value pursuit or value creation is an argument that both sides can make, then the courts oftentimes shift to other bases by which to make the decisions.
Let me throw you a curve here, because Dave Goodman has
asked. And by the way, there's a reason why I mentioned the Fox case.
Why?
Because fox are in Latin, they're called fera naturae in the law, unowned animals, wild animals. Well, when oil and gas became a value in the 19th century, the common law courts had to define, how are we going to define property rights in the people who are pursuing the oil and gas? Because people were drilling at the same time for the oil and gas. And so the court said, we're going to rely on this rule of fera naturae and the rule of capture. And so oil and gas, to this very day in some jurisdictions, is still defined in the law as a wild animal.
Liquid foxes.
It's a fox.
Black fox. Dave Goodman, we're almost at the end, but he asked a fascinating, difficult question. Suppose technology is invented in the future that can control the weather. I want it 72 degrees and sunny year-round. My neighbor wants snow and seasonal changes. How would you apply property rights to this?
That's a great question. It's hard for me to answer because if there's technology to control the weather, there's all the technology for your neighbor to control what weather they can have over their home. And then you have,
obviously they can't control it unless they get unanimous consent, I would say. I shouldn't say obviously, that's simply,
Yeah, I think so. Well, this would, so I think the courts would resolve these issues, I think, using the principles already developed and enunciated through Nuisance Doctrine, because these are the types of disputes that arose in the Industrial Revolution with factory owners producing pollution and polluting a stream, and then fishermen saying, I fished in the stream and now I can't. And I had what's called a riparian right to fish in the stream, and now I'm unable to do that. And the factory owner saying, yeah, but I'm using my property in a valid way to use it. And so, this is the beauty of the law, and kind of that these scenarios are very complex and they're very specific to, well, what type of, are you really using your property within the scope of your valid use rights? Are you actually infringing on someone else's pre-existing use right? So, for instance, already established in the law is the principle you don't have a right to sunlight.
Don't have a right to what?
Sunlight.
Sunlight.
Yes, because people built skyscrapers, and then people said, well, I don't like that there's a shadow over my land. So they sued, saying that was a nuisance. And the court said, No, you don't have your use of your property is not dependent upon sun. Now,
Mm.
but of course, but if you're, for instance, I don't, a solar company,
Yeah, yeah,
solar
yeah,
power
obviously.
company,
Yeah. Yeah.
then you couldn't point to those cases and say, see, I can block your sunlight. So,
I want, can I butt in
yeah,
because we're
yeah,
over time, but Michael Sanders asks a question that's right up your alley. Are
yeah.
courts typically good at upholding patents and intellectual property rights?
Oh,
I
they
think this is
were,
against the patent trolls. Is it in
yeah,
relation to patent
yeah.
trolls?
Yeah, so right now, in some areas of the law, no. And they used to be very good across the board. In the 80s and 90s and early aughts, the courts were very good. But starting in 2000, around 2006, 2007, the courts started to hand down a lot of really bad decisions, especially in patent law, but also in copyright law,
Hmm.
that really started to undermine the rights of innovators and creators, and have caused a lot of problems
Oh,
for innovators today.
oh, well, I didn't know that. That's good. I mean, it's good to hear, bad to live under. Um, we
Yeah.
have some other questions, but I think no, there's one more from Michael again. Is the primary purpose of property rights to protect the relationship between thinking and survival?
Oh, that's a fantastic question. I would say yes.
Yeah,
Uh,
I think
That's
I'm ready.
most certainly yes. As Ayn Rand said, right, without the right to property, one cannot have the right to life. Because
Mm-hmm.
property are the values that you create by acting to sustain your life, and the right to property is the freedom you have to create those values and to continue to use those values to sustain your life. And how do you sustain your life? But by your mind. Mind,
Yeah.
and the man's mind is his basic means of survival.
The definition, or at least closer definition, she gives of production, because obviously it protects production, is the application of reason to the problem of human survival. So, yes, Michael, that is absolutely correct. Um, and the others get into more deep philosophical issues that I would like to spend some time on. So, thank you very much. It's very short,
I know,
30
too short.
minutes, stretched to 33. It's been great having you here, especially when we agree.
We have to find something to disagree about. But that would be
Okay.
difficult for me because, for those who don't know, Harry was my professor back in the 1990s. So this is even more of an honor for me to be here speaking with you
And
now.
Adam was my star student.
Oh,
So,
you're all too
a
kind.
real success story. So, thank you for coming, and I hope that you all be here next Monday for the next edition where we take up something that doesn't even exist, God. Bye.
Wow.